Yes, a very good evening everyone. Let's continue with our discussion on fundamental rights. The first right that we were discussing, which was right to equality, and as a part of our discussion we had in the last class discussed article 14, 15 as well as article 16 of the constitution. Article 14 and article 15 of the constitution article 14 of the constitution, one of the most important aspects of our discussion, because it provides us with two rights, that is equality before law and equal protection of law. Equality before law, a concept which is considered to be negative. It is something that we borrowed from the UK. And why is it considered to be negative? Because it denies privilege to any individual irrespective of whatever background the individual belongs to. And we had seen that the concept of rule of law is inherent to the very idea of equality before law. We had also discussed there we had also discussed there the provisions with respect to the the ideas of what what is the meaning of absence of arbitrary powers, how everyone is below the law in the concept of rule of law, and how in India the ordinary law of the land is the result of the constitution. We had seen the exceptions to the equality before law also, which is mentioned under article 361 of the constitution, basically deals with the offices of the president and the offices of the governor. But there are the diplomats that are there, or foreign rulers, sovereigns, all of them are included there as well. Then we moved on to our discussion of article 15. Article 15 specifically talked about prohibition of any form of discrimination on the basis of certain grounds. The grounds being religion, race, caste, sex, place of birth. Where article 15 clause 1 talks about general prohibition on the state to take up discrimination, article 15 clause 2 specifically deals with social discrimination, and it is not only extended to the state. That means not only state is prohibited from discriminating, but also private individuals. Then we moved on to our discussion of article 16, which was about equality of opportunity. And there we discussed specifically the fact that the state is prohibited to take up any form of discrimination which is either falling into the categories of religion, race, caste, sex, place of birth, residence or descent. These were the grounds that we discussed. Then we looked at the exceptions to it. We did talk about certain constitutional amendments also. We talked about the Indira Sawhney case as well. Clear? Now we move on to the next part of our discussion there, which is article 17 of the Indian Constitution, which deals with abolition of untouchability. Abolition of untouchability. Now, article 17 of the Constitution simply says that it prohibits untouchability and practices any form of untouchability. So it says that articles, if you look at what article 17 says, article 17 simply prohibits the practice of untouchability in any form. The practice of untouchability in any form. Now, article 17 of the Constitution does not define what untouchability is. It does not define what untouchability is. Article 17 does not define what untouchability is. It is very interesting that not only article 17 does not define what untouchability is, rather there is no law in India defining what exactly is meant by untouchability. There is no definition of untouchability. But the idea is very, clear. See, if you define what are the practices which could be classified as a practice of untouchability, it means any practice which does not fall under that very definition would not be prohibited. It would not be prohibited. See, the idea, it's not, no, it's not an, no, don't think of, not if the constitution is not defining untouchability, don't think of it as an, no, as an, that the members of the constituent assembly deliberately overlooked it or mistakenly have overlooked it. No. If you define something, like if there is a practice of untouchability, if it is defined, then there would be a problem with it. The reason being, any other practice which does not fall under that definition would then be legal. Why? Because then it would not fall under the definition of untouchability. So, not defining untouchability is a deliberate attempt where, so that none of such practices escape the purview of law, and that is the basic reason why untouchability as a practice has not been defined. Are you getting what I am trying to say? See, if we define something, the definition becomes very static. That means anything that falls under that definition would be punishable, and anything that falls outside that definition would not be punishable. And we do not want that kind of rigidity revolved around the very idea of untouchability. The reason being, untouchability as a practice has number of forms in which it is basically practiced. And that is the reason why there is no definition of untouchability. However, the judiciary has defined untouchability, and the problem with defining untouchability would, you would see when you look at the definition. The definition that has been given by the judiciary is that it is something, it is, you can say it is a disability. Untouchability is a disability arising out of an individual's birth, solely out of an individual's birth into a specific caste, a practice which is common among the Hindus. This is what the judiciary says. This is what the judiciary says. See, what is the judiciary saying? It's a practice which is common among the Hindus, and where the individual is discriminated against. Why? Solely on the, for the reason that he is born into a specific caste. The problem is that if you just consider untouchability to be a practice among the Hindus, you are wrong. You are wrong. It's not a practice just which is common among the Hindus. Yes, it is a practice which is very much which has been and which is still not at what extent it used to be, but it is still being practiced among the Hindus. There is no denying the fact. But there are other religion also which very much practices the, in some or the other form, the idea of untouchability. It is very much there. And that is the problem. When you try and define such a social malpractice such as untouchability, if you specifically point out that it is a practice among a specific religion, now what does that mean? You are not considering the practices which are there in other religion as a part of being, the practice of untouchability. And if you give such a definitions, the law which has been enacted specifically for prohibiting untouchability, now the acts which are there in other religion will not necessarily fall under the purview of this particular law. And the judiciary has made a mistake in this context, where it says it is a practice solely among the Hindus. That's wrong. It is very much something which has been practiced in Christianity, in Islam, as well as in Sikhism. It is a practice, it has been there. There was a documentary which came out in the year 2000, I think it was in 2005 or 2006, which there were two individuals who traveled across India and were specifically documenting the practices that are there in Indian culture related to untouchability. So it was very much a practice among Hindus which was documented, but it was also a practice among Muslims, who that is followers of Islam or Christianity or Sikhism. So we cannot just say that, that is the very reason why a law or for that matter the constitution has refrained from defining what is meant by untouchability. Because the constitution specifically says, just look at the idea that article 17 presents. It simply says untouchability is prohibited in any form. It is prohibited in any form, which means it doesn't matter. It does not matter whether an individual, is of any religion, or for that matter any practice. It is all prohibited. It is all prohibited. There was initially a law, Untouchability Offences Act of 1955, which prescribed punishment, that if you are found guilty of such practices, in that case what will be the result of it, and it prescribed punishments. But the 1955 law was criticized of not being stringent enough, and that is the reason why in 1976 this law was amended. A new law, Protection of Civil Rights Act, was in 1976 enacted, and this is the law which prohibits which prescribes punishment for the practice of untouchability. An additional thing that you need to understand is that untouchability, and when we say article 17, it does not prohibit just the state from practice of untouchability. It also prohibits any individual. So article 17 is something which is not just applicable against the state, it is also applicable against any individual, private individual, like article 15 clause 2. Like article 15 clause 2. Clear? Also, article 17 of the Constitution has no exemptions. No exemptions. So, untouchability is a practice which is completely prohibited without any exception or without any exemptions to it. So, if we talk about article 15 of the Constitution, we did discuss that article 15 of the Constitution has a list of exemptions. Similarly was the case with article 16 of the Constitution having a list of exemptions. But there is no exemption to article 17 of the Constitution. In fact, this is the only provision among fundamental rights which has no exemptions at all. There are no exemptions. If we talk about laws with respect to discrimination or with respect to rights that are being given to individuals, article 17 is the article which has no exemptions, which means the Constitution visualizes that the untouchability as a practice will be completely eradicated. Not even a single exemption has been provided so as to completely do away with this very practice. And that is the reason why I said this is the only provision of fundamental rights which either prohibits the state from doing something or prohibits an individual from doing something, where there is absolutely no exemptions. There is no exemptions at all. Clear? This is article 17 of the Constitution. Now, moving on. See, as I said, the Mysore High Court had come up with this very idea, and all of this I have provided. Next, the last article under the right to equality is abolition of titles. It is the abolition of titles. It is the abolition of titles. Now, going back to the British period, I have talked about this before also. Going back to the British period, you would find that the Britishers where in a practice of, that is the state, the British Indian state that was there, it was in a practice of providing titles to individuals. So there were people who belonged to, suppose, if they were zamindars or something like that, they were given certain titles. One of the very famous titles, one of the very frequent titles was the title of Rai Bahadur. So an individual during the British period, if they had an exemplary achievement, whether it was whether it was with respect to sports, or for that matter, whether it was some zamindars that were there who were close to the the Britishers, they were provided with this title called as Rai Bahadur. Post independence, the constitution completely prohibits it, and the constitution says that the state is prohibited from conferring titles which to any individual, whether it is a citizen or a foreigner, except for those which are military or academic distinctions. So when it comes to military distinctions, so if suppose we are talking about military ranks, you would find that military ranks are, it is something which is very much used. Why? Because the constitution allows that. So you would find things like lieutenant, lieutenant general, brigadier, or something like these titles that are there. These are very much something which the state does provide. Or for that matter, the state provides academic distinctions like doctor. So if you are either a medical practitioner or you have completed your PhD, you have the state will provide a specific title to that very individual. So if you have if you have either a military distinction or academic distinction, that is the only two kinds of title which is allowed. Otherwise, the state is prohibited from providing titles. Clear? It prohibits a citizen of India from accepting any title from a foreign state. Not only is the state prohibited from providing or giving titles, even an individual is prohibited from accepting titles from a foreign state. So if suppose there is an individual who is to be provided a title by a foreign country, the Constitution of India it specifically prohibits, no individual will do that. So we are not allowed to accept titles. Thirdly, a foreigner holding any office of profit or trust under the state cannot accept any title from a foreign state without the consent of the president. So, if suppose there is a foreigner, forget about citizens of India, we are talking about foreigners who are holding an office of profit. Now, simply speaking, office of profit for today, just understand it in this manner. If you are employed by the government and for that you are receiving a remuneration, for today, I will be dealing with what is the exact meaning of office of profit. I will be talking about a particular article called as Article 102 of the Constitution. And when I discuss Article 102 of the Constitution in details, I will be talking about what exactly is the meaning of office of profit. What exactly is the meaning of office of profit? But for today, office of profit simply means, suppose there is a foreigner who is under the employment of the government of India, or for that matter has been given a specific responsibility in return of which he is receiving a specific remuneration. In that case, that very individual will be classified as an individual who is holding office of profit in India. Clear? So, an individual who is holding office of profit, a foreigner who is holding office of profit in India, he cannot accept any title from a foreign state. He is a foreigner, but because he is employed under the government of India or is doing something for which he is receiving a remuneration, that is the reason why he will not be receiving any title from any foreign country, from any foreign country except with the consent of the president. So, if the president gives his consent, or no, the president says yes, only then he can receive that title, not otherwise. Not otherwise. Clear? Next, no citizen or foreigners holding an office of profit or trust under the state is to accept any present, emoluments or office from any foreign state without the consent of the president. Now again, no citizen or a foreigner holding an office of profit, same definition. Office of profit means he is being employed by the government of India. He has been employed by the government of India, is doing something for which he has been receiving remuneration. So, no citizen or a foreigner who is holding any such office can accept any, not just titles, you cannot even accept any form of presents or emoluments means, salary or something like that, or for that matter, any office from any foreign state without the consent of the president. Clear? So, Article 18 of the Constitution, the gist of Article 18 of the Constitution is that to ensure the existence of equality, the state is completely prohibited from giving titles to its citizens, and the citizens are prohibited from accepting titles from any foreign state. This is basically the gist of what Article 18 of the Constitution is. However, Article 18 clause 1 also says that what kind of titles can be given by the state. What kind of titles can be given by the state are two types. First, if they are military distinctions, or for that matter they are academic achievements. Only then these are the titles which can be given by the state. Clear? Now, my question is, suppose a citizen of India accepts a title from a foreign state, what will be the consequence of it? What do you think? According to you, what will be the consequence of it? Suppose there is a citizen of India, and suppose a citizen of India is or has accepted a title from a foreign country. What will be the consequence of it? What will be the consequence of it? See, if we are prohibited to do something under the Constitution and we'll still do it, there are some punishments prescribed. Like, just go back to Article 15 clause 2. Article 15 clause 2 says what? It prohibits no individual can discriminate on the basis of only of religion, race, caste, sex, place of birth in doing what? In providing access to public places. So, if suppose there is a hotel or there is a restaurant and I deliberately prohibit someone from entering it despite the fact that he has fulfilled all the criteria required. If I prohibit that, in that case I will be punished for that. It may be in the form of, it may be in any form. Suppose that individual calls the cops on me, he calls the police on me. So, if I still resist, it may so happen that they arrest me. There is a punishment prescribed for it. Similarly, untouchability, prohibited under the Constitution. Suppose I practice it. In that case, what will be the result of it? In that case, again a punishment is prescribed and I will be punished for it. It may be in the form of a jail term. I may have to serve a sentence for it. What about Article 18? If Article 18 specifically prohibits a citizen of India from accepting any title from a foreign state, it explicitly says that. But still, if suppose a citizen does accept that title, then what will be the consequence for it? What do you think? Okay, I'll give you example also. All of us know who Yash Chopra is. Yash Chopra was a director, now he is no more, but he used to, he was quite a renowned name in cinema, specifically in Bollywood. Now, if you ever read his Wikipedia page or anything about it, you will find that he has been given titles by certain states like the country France, Switzerland, to be very specific. Till the day he was alive, almost every year he was specifically given certain titles from these countries. My question is that the constitution prohibits it. Okay, he is not voluntarily accepting it. Maybe if it so happens that the state is providing, he is not voluntarily, no, there is no such thing. But if suppose such an event has happened, suppose an individual has accepted a title, then what will happen? पब्लिकली उसका यूज नहीं करेंगे. ठीक है. Anything else? Actually, there will be nothing will happen. Though the constitution prohibits it, but the constitution does not prescribe any punishment for it. See, for me to be punished, there needs to be a law where I have done something, any act which is under that law a violation of it. Only then I can be punished. Go back to our discussion of rule of law. Rule of law says what? An individual can be punished only for the breach of law, and such a breach shall be established in an ordinary court of law. This is what one of the principles of rule of law says. But in this case, though the constitution prohibits that you will not accept a title, but does the constitution say what will be the consequence if you do? It does not say that. Which means even if an individual accepts a title, there will be no punishment that would be administered. There will be no punishment that would be administered. Why? Because Article 18 of the Constitution is only declaratory in nature. It is only declaratory by nature, and it is not penal. It is not penal. It is declaratory by nature, it is not penal. It is declaratory by nature, it is not penal. It is as simple as that. Penal means prescribing punishment, but it does not prescribe punishment. It just declares no one is going to do this, no one should do that. But it does not say if you do it, what are the punishments for it? It does not say that. Clear? So, whenever we talk about Article 18 of the Constitution, this statement is very important. And in your prelims examination, if you ever get a question on Article 18, it would be this statement. It would not ask you what are the provisions, because this provision is something which is known by everyone. Article 18, okay, prohibition of titles. So, even if they do not know all the provisions, they will easily decipher what Article 18 would say. But an understanding is required to come to this conclusion that because Article 18 of the Constitution does not prescribe any punishment for its violation, or for that matter, there is no law in India saying that if you accept a title from a foreign state, this is the punishment that you face. So, even if an individual accepts a title, because he is not violating a law which prescribes a punishment, that is the reason why he will have, there would be absolutely no action that would be taken against that very individual. Clear? And that is what I mean when I say Article 18 is declaratory by nature and it is not penal. This is what I mean when I say this. Clear? Remember this particular statement. Okay. Coming to another discussion under Article 18. If the state is prohibited from providing titles, what are national awards then? Because when you get a national award, 26th of January, you will see that there is declaration of national awards. There are some individuals who would get something called as the Padma Shri awards. Then there is Padma Bhushan. Then there is above that the Padma Vibhushan. And finally there is something called as Bharat Ratna. So if we are providing an individual with Bharat Ratna, Padma Shri, Padma Bhushan, Padma Vibhushan, if the state is prohibited from actually giving titles, what exactly then is these? Padma Bhushan, Padma Vibhushan, we are calling that individual Padma Bhushan this. So if that are not titles, then what exactly are these? What are the national awards? Don't you think it is a violation of what Article 18 of the Constitution says? Because Article 18 of the Constitution says the state shall not confer titles. That is what it says, na? A. It prohibits the state from conferring titles which are not academic or military in nature. But in this case, what we see is that Padma Bhushan is not provided to some individuals who have achieved some kind of an academic distinction. Neither it is military by nature. So if it is not academic and military, then is it not a violation of Article 18 of the Constitution? What do you think? But that is not what the Constitution says, na?
But through them they are recognizing the merit, and the theory of equality does not mean that the merit should not be recognized.
Yes, exactly. Actually, the concept of national awards were challenged in the Supreme Court. It was challenged in the Supreme Court that when the Constitution explicitly says that the state is not going to provide or confer titles, then why and what exactly then are national awards? And isn't it then a violation of what Article 18 of the Constitution is? Isn't it unconstitutional? The Supreme Court in the Balaji Raghavan versus the Union of India case said no, it is not. The Supreme Court was of the opinion that, first of all, they upheld the constitutional validity of these awards, and the Supreme Court said when Article 18 prohibits the conferring of titles, it does not mean the state is prohibited from recognizing merit. The state is obviously prohibited not to provide titles, but it does not mean the state is prohibited from recognizing merit. The state is not prohibited from recognizing merit. And further, in this very case, the Supreme Court said these national awards that are there, they are in recognition of some outstanding achievements of certain individuals, and hence it can be considered as academic distinctions or in nature of academic distinctions. And the Supreme Court upheld the constitutional validity of national awards. Despite the fact that it is there, and the Supreme Court explicitly said that even those individuals who are recipients of such awards, they would the Supreme Court did not the Supreme Court actually came up with an observation. They did not rule this, they came up with an observation that those who are recipients of such awards, they would not be using it as prefixes to their name. It would not be used. It is just recognition of merit, but it would not be used as prefixes to their name. But again, in India we do that. You will find that if suppose there are people who are recipients of such awards, whenever they are to participate in such some events which are public by nature, when they are introduced, they will always be introduced as Padma Bhushan this or Padma Vibhushan this. Actually, it is not what should happen, because the Supreme Court was not in favor of doing this. The Supreme Court was saying that yes, merit should be recognized, but it does not mean you are you are going to use it as prefixes. That should not be done. But despite that, it is done. Clear? This is what Article 18 of the Constitution is. And with this, we complete our discussion on right to equality. We complete our discussion on right to equality. Any problems? See, today we have first discussed Article 17, abolition of untouchability. And then we have come to Article 18. This is what we have discussed in Article 18. Clear? No problems? Should I move forward? Next fundamental right. So, the next fundamental right is right to freedom. The next fundamental right is right to freedom, the second fundamental right, and Articles 19 to 22 of the Constitution deals with this very right. Articles 19 to Article 22 of the Constitution, it deals with right to freedom. Clear? Now, if we go back in our discussion and if we try and recall the preamble to the Indian Constitution, and if we recall the preamble to the Indian Constitution and look at the basic purpose that the preamble had, we came up with 4 purposes. First purpose was that the preamble tells us what is the nature of Indian state. The preamble describes the Indian state as sovereign, socialist, secular, democratic, republic. So that is the nature of Indian state. The preamble also tells us, the second purpose was that what does or what kind of state, what kind of society the Constitution wants to be delivered. So what is the features of a society? What are the features of a society which the Constitution of India wants? And it says what? It says justice, equality, liberty and fraternity. So it tells us that as a citizen of India, what can you expect from the Constitution? So you can expect that the Constitution would be successful in delivering a just society, a society which is working on the principles of equality, liberty and fraternity. The concept of liberty that we discussed, in the preamble, liberty had also various dimensions that were mentioned. So it did say liberty, but it further also said what kind of liberty. It said liberty of belief, faith, worship, liberty of expression. It did say that. So liberty, the concept of liberty, it is so important an ingredient to Indian Constitution, or for that matter any constitution across, any democratic constitution across the world. There cannot be a democratic constitution without liberty as the principle there. There cannot be. There cannot be there cannot be a constitution, or there cannot be a society which does not have the principles of liberty guiding it, and the country being a democratic country. These two things, they either go hand in hand or they are not present at all. So democracy works on one basic principle of liberty. what we are now going to discuss, that is the fundamental right to freedom, this this is fulfilling that very condition of liberty, the goal of liberty, as the preamble of the Indian Constitution had promised. Clear? So under Article 19, 20, 21 and 22, we are going to talk about different rights which gives us as a citizen of India certain forms of liberty. Certain forms of liberty. It may be political by nature. Some are political by nature. Some are vocational by nature. Or for that matter, some are just a certain kind of liberty which is required for any individual to survive and grow. Like if we talk about right to life. Clear? So what we are now going to talk about is considered to be, if not the most, the most important of the fundamental rights, at least a right which is something which falls within the domain of being one of the most fundamental, one of the most important fundamental rights. Clear? And the first right that we are going to discuss here is Article 19 of the Constitution, which is which provides us a set of rights. Article 19 does not just give us one fundamental right, rather it is a set of, it does give us a set of fundamental rights. In fact, Article 19 of the Constitution gives us a set of 6 fundamental rights or 6 rights. Initially, it used to be 7. It used to be 7 because right to property, right to property was a fundamental right which was included as the 7th right, but through the 44th constitutional amendment, this right was, it was actually done what? It was disposed. It was repealed from Part 3. It is still a constitutional right. Under Article 300A of the Constitution, it is still a constitutional right, but it is no more a fundamental right. So whenever you are using the term repeal, you have to be very careful, because it was not repealed from the Constitution. It was only repealed from Part 3 of the Indian Constitution. It was only repealed from Part 3 of the Indian Constitution. Clear? So it initially used to be 7 rights. Now these are only a set of 6 fundamental rights. And what are those rights? Right to freedom of speech and expression, right to assembly peacefully without arms, right to form associations, unions or cooperative societies. This term cooperative society, it was added. Initially, it was not present, cooperative societies. It was added to the Indian Constitution by the 97th Constitutional Amendment Act, which was taken up in the year 2013. So, right to form associations, unions or cooperative societies, right to move freely throughout the territory of India, right to reside and settle in any part of the territory of India, right to practice any profession or to carry out any occupation, trade or business. These are the set of 6 fundamental rights. Clear? We are going to discuss them one by one. The first of this fundamental right is right to freedom of speech and expression. Right to freedom of speech and expression. This is a very interesting right. It is one of those fundamental rights which you are going to hear the most when it comes to news channels. It is one of those fundamental rights which the government is frequently accused and alleged of some or the other way, imposing certain restrictions on it. See, right to freedom of speech and expression simply means we as citizens of India, we have the right to speak as well as express ourselves. And when we say right to speech and expression, what you need to understand here is that this right is available to us in, we can, it is said that we have this right which we enjoy freely. When I use the term freely, what does that mean? It means when I enjoy my freedom of speech and expression, this speech and expression of mine is not subjected to any form of coercion by the state. So the state cannot in any way repress my right. The state cannot in any way force me not to speak about something. That is what is meant by the term freely. And when we say right to speech and expression, right to speech and expression is not literally interpreted just as speech and expression. It is through the use of any medium. So I can speak, I can put up symbols, or you can say put up a board talking about what I want to speak about. I can advertise. All of this is a part of freedom of speech and expression. So any medium that I want. So freedom of speech is not to be interpreted always literally. It's not a literal interpretation that it only means your speech or you expressing yourself. No, it does not just, it's not literally the meaning. In fact, the meaning goes beyond just speech and expression. It can be, words that are spoken, written, or for that matter, expression in any other form, any medium that we can use. Clear? So this is what freedom of speech and expression is. But the important idea here is that over the period of last, since the coming up of the constitution and, over the period of last more than 70 odd years, the concept of freedom of speech and expression has undergone interpretation by the court number of times in number of cases. It has come in front of the court exactly what is meant by speech and expression, and on the basis of that, there has been the way the Supreme Court or the High Courts have interpreted freedom of speech and expression, it has broadened the scope of what is the meaning of freedom of speech and expression. It has broadened the meaning of what freedom of speech and expression is. Like, if you look at the Supreme Court says freedom of speech and expression includes freedom of silence. So, as I said, not what is the meaning of it literally. So, literally speech means only speech, but silence has been interpreted as a part of Article 19. It is a fundamental right. It is a way, I express myself, and hence it is a part of Article 19 1A. Right to sports has been included as a part of Article 19. Right to advertise has been included as a part of Article 19 1A. Right to press has also been included as a part of Article 19 1A. Now, when I say right to press, how is it different from right to speech? See, right to speech is what I think about a particular issue. So, what I think, what my views are, is what is speech. Right to press includes what others' views are on that very issue. So, when I am expressing you in a manner, in either through words spoken or words written, it is what right to press is. Right to press is. Right to protest has also been included as a part of right to freedom of speech and expression. In fact, protest by holding hands and taking up a silent march, it has been included as a part of right to freedom of speech and expression. Right to upholding of the national flag has been included as the part of right to freedom of speech and expression. So, holding of national flag is also considered as a mechanism of protest, So, if I do not agree to certain policies of the government or for that matter of any institution, in that case when I take up a protest holding the national flag, it is the right that I have under Article 19 of the Constitution. If we go back, around around a decade back, you will find that this was not a right that we had. In fact, national flags were not to be hoisted every day, or it cannot be, it could not be hoisted anywhere. No, like if we talk about, going back around 10-15 years, there was a specific code that was to be followed. Like if I had to hoist the national flag on a private building, it could be done only during certain events, like if it was the 26th of January, 15th of August, not otherwise. And there were certain codes that were there, but later on the Supreme Court said no, it is a part of an individual's speech and expression. So even that, an individual can hoist the national flag, even in his private building he can do that. There is no problem with it. Yes, he will have to subscribe to a certain code, like the flag should always, it should never be dirty. If suppose there is a something which has been declared as a national event, like if you know how we actually recently when Lata Mangeshkar died, she was the recipient of Bharat Ratna. So when an individual who is of such a stature passes away, so there is a specific code that is followed by all government buildings. What they do is they hoist the national flag midway, they actually bring it down a bit. So that's a code that is followed, and if you are hoisting the national flag, you should also follow that code. Previously this was not allowed. Private individuals hoisting national flag in their private property was not allowed, only except for certain cases in certain days. But now it has been made a part of it. However, hoisting of national flag does not include the right to burn the national flag. We do not have that right. We do not have the right in any way to do anything which can be considered not under the decorum of how national flag should be treated, because there is a law for it, and if you do that, you will be punished under that very law. In US, they also have the right to burn the national flag as a show of protest. So if you are protesting against a government's decision, they also have a national flag code, and they also have a specific a specific code on when, where to use the national flag, where you cannot use the national flag, how you can do it. So they have the right to burn the national flag. If you are protesting against the government on certain issues that the government, on certain policies, etc., if you are burning the national flag, that is allowed, but you cannot stamp on it. If you do that, that is a violation of the code and you can be arrested for it. There is a specific code that is there. So if you look at Article 19 of the Constitution, over a period of time, there has been such interpretation of Article 19(1)(a), that is right to freedom of speech and expression, that there has been a number of inferred rights which have come under the ambit of Article 19(1)(a). Inferred rights, they are not explicit. What are inferred rights? Inferred rights are those rights which are not explicit They are not explicit rights. They are not explicit rights, but they definitely have been inferred as a part of this specific right. You can see this right to propagate one's views as well as the views of others. As I said, right to press, freedom of press, freedom of commercial advertisements, right against tapping of telephonic conversation, right to telecast, right to right against band called by polity, against band, not right to band. Remember this. It's not right to band, it is right against band called by political parties. Right to know about the government activities, nothing but right to information. It has been included as a part of it. Right to silence, right against imposition of pre-censorship, right to demonstration or picketing, but not the right to strike. Remember this, we do not have the right to band or we do not have the right to strike. It is not considered as a part of Article 19(1)(a). But the way it has been interpreted by the Supreme Court, now it is not something which is just right to an individual's freedom of speech and expression. The scope of right to freedom of speech and expression has been broadened to an extent wherein it has include within itself number of inferred rights. And Article 19(1)(a) of the Constitution, when we are talking about inferred rights, is only second to Article 21. Because Article 21 of the Constitution also has right to life, also has a number of inferred rights within it. It also has a number of inferred rights, and Article 19(1)(a) is only second to Article 21 of the Constitution in terms of the inferred rights that it has been included within its ambit. Clear? Have you understood this? Now, in addition to this, there is certain other things that you also need to understand. Now, when I say right to freedom of speech and expression, always remember this right is available to an individual irrespective of national boundaries. Irrespective of national boundaries. Very, very important. When I say irrespective of national boundaries, what does that mean? Is this right available to foreigners? No, it is not available to foreigners. Irrespective of national boundaries does not mean that this right is available to foreigners. It means if I am a citizen of India, but I am not present in India, if I am a citizen of India, but if I am not present within the national boundaries of India, even then you cannot deny me this right. Even then you cannot deny me this right. So you cannot just deny me the right just because I am not present within the national boundaries of India. So if suppose I am an individual who is right now outside India, but I would like to talk to the press on a specific issue, you cannot just impose a restriction on it based on the fact that I am outside India. You cannot do that. I still will enjoy the rights that have been given to me under Article 19. Clear? Second, right to information is a right within Article 19(1)(a). That is, it is one of the inferred rights. It is one of the inferred rights. I am highlighting this explicitly. The reason is that this is a question that is asked. Suppose you get this particular statement in your prelims examination. The statement says the inferred rights under Article 19 are also fundamental rights available to citizens of India. Is the statement correct? Is the statement correct? Inferred rights, are they constitutional fundamental rights? Inferred rights. So if we talk about these rights that are there, are these rights fundamental rights? No, they are not. They are not. They are not fundamental rights. They are just rights which have been inferred to be a part of this particular article, but they are not. They have not been declared as fundamental rights. They have only been declared as inferred rights. Try and understand this. What exactly is the meaning of this very idea of inferred rights? It is a right which is which ensures better implementation of the fundamental right. What did I say? I said it is a right which ensures better implementation of the fundamental right. So if we have right to freedom of speech and expression, right to freedom of speech and expression would be incomplete if we do not have the right to press, or if we do not have the right to advertise, or if we do not have the right to silence, or so and so on. So when we say inferred rights are not fundamental rights. Inferred rights are those rights which have been inferred by the court to be a part of it, only to mean that with the availability of such inferred rights, the fundamental right can be better implemented. It only means this, that with the availability of such inferred rights, the fundamental right can be better implemented. These are not fundamental rights. These are not fundamental rights. Whenever the Supreme Court finds a right to be so important that it declares the right in itself to be a fundamental right, it will rule accordingly. So in any of its decisions, it would say this is a fundamental right. It would say this, the judiciary would say this, it is a fundamental right. But in these cases, the Supreme Court has never considered them to be fundamental rights. The Supreme Court has just said that these are inferred rights within Article 19. Clear? So there is a difference between a right being an inferred right and something being a fundamental right. And you should not in any way get confused over it. Ever you get a question, right to information, is it a fundamental right? Answer is no, it's not a fundamental right. It's just an inferred right. In fact, right to information in India is a statutory right also, because in 2005 we had enacted a law on it. So it's a statutory right. It's an inferred right, but it is not a fundamental right. Clear? Clear? Are you getting the meaning of it? This is something that you should understand, because I have seen multiple times a question on such a specific, specifically this question has been asked, and there are number of aspirants who tend to make mistakes, because you will always read it in this manner. Okay, Article 19, Lakshmikant says Article 19 includes these rights and hence it is also a fundamental right. No, it does not say it is a fundamental right. It only says it is an inferred right within Article 19. So I will something that is explicit, only that is a fundamental right. Something which is implicit is not a fundamental right. Clear? So this, what has been done, these rights, these list of rights that are there, it has been made a part of this inferred rights, like right to freedom of freedom of information. Clear? Third, Article 19(1)(a), which says freedom of speech and expression is mandatory for existence of a multi-party democracy. It is mandatory for the existence of a multi-party democracy. Now let us just correlate this idea. Suppose you get this statement in your mains examination and it says examine or substantiate. So how will you proceed? What is first of all a multi-party democracy? A multi-party democracy, a very good example of it is India, because we have multiple political parties that are there. All these political parties have the right to contest elections and they have the right to spread their own ideology. which means they have the right to talk about their ideology. They have the right to talk about the policies and programs that they are specifically, no, they are going to implement if they come to power. They have what is called as the right to come up with a political manifesto, and so on. So there are multiple political parties. That's a multi-party democracy. If you look at certain other examples, like if we talk about an example of UK, or for that matter US, are these multiple multi-party democracies? The answer is no, they are not. Like if we talk about US, in US primarily speaking there are only two political parties. There are only two political parties, one is the Democrats and the other is the Republican Party. Similarly, if you look at UK, you will find there is a Labour Party, there is a Conservative Party. These are the two main important political parties that are there. These are not multi-party democracies. They are unlike India. They are unlike India. And for a multi-party system, it is very important that you have this right, because without this, that is without the freedom of right, freedom of speech and expression, you will not have the right to do what? You will not have the right to express your ideology. You will not have the right to criticize the other political parties' ideology. Now, see, as all of us being a citizen of India and of a certain age, we understand political issues. So, if I hear a member of a political party whom I do not subscribe to, so I do not subscribe to the ideology of that political party. So, does that make that individual in any way, is any limitation imposed on him, on his freedom of speech and expression? Absolutely not. So I may not like the individual or the political party, the ideology of the political party, but it does not mean that that individual does not have the right to speak about his own political party's ideology, and it does not mean I do not have the right to criticize him. I have the right to criticize that individual, the political party. I have the right to talk about my own ideology, my own political party. Without the freedom of speech and expression, we will not have a multi-party democracy in existence, because then it may so happen that the ideologies are, or one or two ideologies, like what is the case in US or in UK, that is what you are going to find. For existence, continuation as well as maintenance of a multi-party democratic system, you require freedom of speech and expression. Without this, it is not possible. Without this, it is not possible. As an individual, I have the right, there may be a political party in power, but I have the right to criticize that political party. I have the right to criticize the ideology of that political party, the policies and programs of that political party, the behavior of the members of that political party, and also I have the right to advertise for my own political party, my own ideology, my own policies and programs. And because these rights are inherent in freedom of speech and expression, that is the very reason why we have a multi-party democratic system. That is the reason why we have a multi-party democratic system. See, in India, there are political parties who win elections just by giving freebies. Just by giving freebies. There may be a political party who would talk about things like, if we go back, like if we go back to the UP elections around 10 years ago, Samajwadi Party had promised that every individual who is of age of 18 years or above will be getting a laptop when they win elections. When they win elections. If you go to the state of Tamil Nadu, when Jayalalitha was, when she was alive and she was contesting elections in the AIDMK, she had promised that every household will be getting a color TV. Now the question is, where is the money coming from? It is coming from people's, obviously the people are paying taxes for it, but are we paying taxes for such things? No. But do I, no, have I, no, have I the right to criticize that? Yes. I have the right to criticize it. So when you, make such promises, I have the right to criticize it and have the right to propose an alternative plan. That will be the plan of my political party. That is my economic ideology. And that only is present when it comes to right to freedom of speech and expression. Without this, we don't have that no right to criticize or talk about, freely talk about, our ideologies, or for that matter our economic policies and programs. So for a multi-party democratic system, it is something that is absolutely a must. Without this, there is no multi-party democracy that will exist. Clear? And we have already seen the idea of liberty. If we want a democratic system, we have to provide liberty. In India, you will see there are political parties and there are political individuals talking all short of rubbish. They will they will not talk about the issues that are there in hand. But the thing is that it does not mean they do not or they should not have this right. It is upon us to choose wisely. That okay, this political party or this political party or that political party, it is upon us to choose wisely. But if I do not like a political candidate or a political ideology or the policies of that political that political party, it does not mean that that political party will not have the right to put those policies and those programs in front of the people. They will also have that right. Clear? And that is what we mean by liberty. That is what we mean by liberty. And that is important for the existence of any democratic system. Clear? However, we have previously discussed also what? We have previously discussed that the fundamental rights that are there, they are not absolute. They are qualified rights. We had discussed when we were talking about features of fundamental rights. What does this mean? They are not absolute and they are qualified rights. What does that mean? Can you just recall what we had discussed? Yes, can you just recall? Why did I say they are qualified rights and they are not absolute? What does that mean? Yes, they are not absolute means there can be reasonable restrictions imposed on my fundamental rights. So it does not mean that my right is like an absolute right. I will do whatever the right, whatever rights I have without thinking about others. No, there can be some reasonable restrictions that can be imposed. Now, there are two things. First, the restrictions are there. So these are restrictions make these rights what? Qualified. They are not absolute. But these restrictions should be reasonable in nature. This is also very important. These restrictions cannot be unreasonable. Restrictions have to be reasonable. And who decides that? It is the judiciary. Who imposes the restriction? Who imposes these restrictions? The parliament. It would be the parliament who would impose these restrictions. But who would decide whether those restrictions are reasonable or not? It is the judiciary who will decide. If the judiciary finds any restriction to be unreasonable, in that case what will happen? It will declare it to be unconstitutional. It will declare it to be unconstitutional. Clear? Now, when we say freedom of speech and expression, what are the grounds on which our freedom of speech and expression can be they can be reasonably restricted? The grounds are sovereignty and integrity of India, security of the state, friendly relations with foreign state, public order, decency or morality, contempt of court, defamation, and incitement of an offense. These are what? These are reasonable restrictions that are imposed. These are reasonable restrictions that are imposed. Let's talk about these reasonable restrictions. So, what are the reasonable restrictions? First is the sovereignty and integrity of India. Sovereignty and integrity of India. See, I have the fundamental right to freedom of speech and expression, but it does not mean I am going to challenge the sovereignty and integrity of India. It does not mean that. So, in exercise of my right to freedom of speech and expression, in exercise of my right to freedom of speech and expression, I cannot say something, I cannot say something, or I cannot express myself in a manner which challenges the sovereignty and integrity of India. Like, you must have heard about something called as sedition. You must have heard about something called as sedition. Section 124A of the IPC deals with sedition. And there are cases where you will find people are charged with sedition. I'll give you an example for it. Today itself, if you have read the newspaper, there was a specific news on an individual whose name is Sarjeel Imam. Do you know who he is? No. So when the CAA protests were going on, so he is an individual who was still studying in JNU, and in one of the universities, he had organized, you can say, a meeting wherein he had specifically talked about things like coming up with a plan to impose some kind of problems where India's northeast could be cut from the rest of mainland India. So he was talking about doing something like this, which could lead to this. If you know about the geography of India, the northeast of India that is there, the northeast of India is connected to mainland India by a very small corridor called as the chicken's neck. So he was talking about that chicken's neck. He was talking about the fact that how could this chicken's neck be used and the northeastern part of India could be cut from the rest of India. Now the video that was released, it was not some claim that it was doctored video and it was not the original video, whatever is the case, that is sub judice, and that is upon the judiciary to decide. But when you are exercising your freedom of speech and expression, you cannot go to an extent wherein you can start claiming and inciting people to do this. That is a direct contradiction of what? Sovereignty and integrity of India. You are talking about doing something which could cut a specific part of India from mainland India. You are challenging the very integrity of the nation. Even if you have the freedom of speech and expression, you cannot do this. And if you do it, there are laws like the sedition law, which we will be talking about, and that sedition law, through that sedition law, what can happen? There can be certain restrictions imposed on you. There can be, you can be charged of sedition to an extent wherein you can be imprisoned for life under the sedition charges. It is a violation of integrity, it's a violation of freedom of speech and expression, but it acts as a reasonable restriction on your freedom of speech and expression. It acts as reasonable restriction on your freedom of speech and expression. See, security of the state. So you would find that there are people or there are agencies, there are people, there are agencies who are dealing with sensitive information, and if those informations, it is leaked or something like that happens, in that case what is the end result of it? It might result into what? No, certain challenges for the security of the state. So on the basis of this, there can be some restrictions that can be imposed. There can be some restrictions that can be imposed. Like tomorrow when you get into services, tomorrow when you get into services, you are going to sign a document in which you are going to swear secrecy. You are specifically going to sign that document wherein you are going to swear that I will not disclose all these information. There would be certain things wherein you would be specifically told this is not something that you can disclose, and you will not be talking about it outside obviously your whatever your government duties are. You are not going to go beyond it, because then it becomes even if you have freedom of speech and expression, it will act as a reasonable restriction on it. Then see, friendly relations with foreign state. Now, through an example, let's try and understand this. We all know about the Tibet issue. I hope you know about the Tibet issue. So Tibet was an autonomous region which was occupied by China in 1951. It was occupied by China. And since then, that is since 1951 itself, there have been people who have been given political asylum in India. There are people from Tibet who are living in India because their spiritual guru, the Dalai Lama, has been given political asylum in India. So they have been living in India. So whenever an important representative, Chinese representative, suppose comes to India, so what will happen? You will find the day he is supposed to, suppose he is going to some places, in that very route, all of that very route, you will find that there is a major police presence, and they will not allow any individual who is protesting in favor of having Tibet's autonomy or China leaving Tibet. They will not be allowed to protest. So you will find that they will not be allowed to take a flag, the Tibetan flag that is there. All of this would be prohibited. See, if you look at the freedom of speech and expression, it says right to propagate one's view as well as the view of others, which means if they are dissatisfied with a specific step of a foreign government, they have the right to do what? They have the right to protest against it. But despite the right that has been given, which is a fundamental right, you will find that there are some restrictions imposed. Like that day, you will find there are restrictions on the movement. So the metro stations would be closed. There would be some restrictions that would be imposed on those areas where that the individual is supposed to go. There would be restrictions that would be imposed. Why? To maintain friendly relations with a foreign state. Similarly, public order, decency and morality. See, my freedom of speech, go back to our discussion of the idea of a qualified right. Why is it that these are qualified rights? Why isn't that these rights are absolute rights? If you remember, the reason that we talked about was that there is a need to maintain a balance between individual rights and the rights of the society. It is not that I can enjoy my rights at the cost of your rights, at the expense of your rights. No, that is not what we are supposed to do. We are going to enjoy our rights in a manner that it does not encroach upon the rights of others. And that is what is meant by having a balance. There should be a balance between the right of an individual and right of a society, of the society. Now, if you look at this, public order, decency and morality, what is this? Public order, decency and morality are certain reasonable restrictions which would ensure that an individual in exercise of his rights do not start violating the rights of others. So, if I am in a public place, in a public place, I don't expect people to, to be abusive in the language that they use there. That is against what decency and morality dictates. That is against what decency and morality dictates. Freedom of speech and expression is there, but it does not mean you will start using a language which is abusive. If you do that, there can again be certain restrictions imposed on you. Why? Because it again goes against decency and morality, or it may cause chaos, go against public order. It may go against public order. It can happen. And as I said, there is a social right. A social right is what? In public places, people are going to act in a certain manner. I expect when I'm going outside my house, I expect people who are around me not to behave in a manner which is against what decency or morality dictates. Even if you have this right, it does not mean you can encroach upon my rights. That is my right. You cannot encroach upon my right. Clear? Similarly, contempt of court. Now, this is very important. Let's talk about this. Do you know what is the meaning of the term contempt? Yes, what is the meaning of the term contempt? Ha. Now, see, if you look at the Constitution of India, the Constitution of India under Article 129 declares the Supreme Court of India to be the court of record. And similarly, under Article 215 of the Constitution, the High Court is declared to be a court of record. So, you have declared a court to be what? Court of record. When we say a court is a court of record, like the Constitution declares Supreme Court and the High Courts to be court of record, what does that mean? Suppose the Supreme Court has been declared the court of record, or the High Court has been declared the court of record. What exactly is meant by it? What exactly is meant by it? Being a court of record. Court of record means two things. The court of record means two things. Listen to me very carefully. I expect a question from contempt of court. What does it mean? Two things. Contempt of court means that, first of all, court of record means the court or the proceedings of the court is a matter of record and can be used as evidence. Can be used as evidence in any court, in any other court. I'll explain this, don't worry. And second is, court of record also means a court has the power to punish an individual in its contempt. The power to punish that individual in its contempt. In its contempt. So, whenever a court is declared as a court of record, the court of record means whatever is going on in that court, whatever the proceedings are, it is a matter of record. and it can be used as evidence. It can be used as evidence. Now, what does this first idea mean? Let's try and understand this through an example. The example would go something like this. Based on our earlier discussion, we know about the basic structure doctrine. Basic structure doctrine, we all know about the basic structure doctrine. That means, according to the Keshav Nanda Bharati case, the Supreme Court has said what? That there are certain provisions which are part of basic structure of the constitution, and those which fall under the basic structure, they cannot be destroyed by the parliament. They cannot be destroyed by the parliament. And if you remember, we had also discussed that in the same case, the Supreme Court had also declared what? That judicial review is a part of basic structure. Now, any court which is a court of record, every proceeding of that very court is a matter of record and can be used as an evidence. Suppose a particular case comes up either in front of the Supreme Court or in front of any other court, suppose a high court. There is a matter which comes up, and in the matter the same idea, that is judicial review, is being debated. There has been some act of the legislature which contradicts the provision of judicial review. I am suppose an advocate who is present there, who is taking up that debate. During my debate, I will, if I have to suppose prove that this whatever the law is, it is going against the judicial review. Suppose I am debating that. So if I have proved that the law which has been enacted by the legislature, it is in contradiction to the provisions of judicial review, should I or have I to also prove that judicial review is a part of basic structure? No. Why? Because the proceedings of the court of record is a matter of any court which is declared as a court of record is what? It is a matter of record and can be used as an evidence. So what will I do? I will not prove that judicial review is a part of basic structure. I will just refer to that very case. I would say, in accordance to the Keshav Nanda Bharati versus the state of Kerala case, the Supreme Court took up this matter and declared the judicial review to be a part of basic structure. The court, which is now the judges who are listening to what I have to say, whatever I am arguing, they will have to accept it as an evidence. Yes, he has proved that it is a part of basic structure. Why? Because it was an earlier decision and that has been presented as an evidence. I'll talk about something very similar. In India, capital punishment is allowed. Do you know what is capital punishment? Being hanged. Death penalty is what is called as capital punishment. In India, capital punishment is allowed. Do you know in what cases capital punishments are allowed? Can anyone in any case be given capital punishment? No. If you look at the law very clearly says in the rare of the rarest case. In the rare of the rarest case. So, capital punishment is to be awarded to an individual who is proved to be guilty of a crime which is obviously very heinous by nature, and it is proved that this particular crime is also rare of the rarest case. Only then the individual will be awarded death penalty. Clear? Now, I am just correlating two ideas. Listen to me very carefully. Suppose there is a case which comes in front of the high court or the lower court, which is very similar to an already, a case which has already happened, and the Supreme Court or the High Court has already declared their judgment on it and has declared that that is a case which is the rare of the rarest case. Simply, I'll just simplify. there is a case which comes in front of the lower court. In that case, the case is very you can say the events of that very case is very similar to the Nirbhaya case. We all know what was the Nirbhaya case. Now, in Nirbhaya case, this matter was first tried in the lower court, appealed in the high court, appealed in the Supreme Court. The High Court, lower court and the Supreme Court, all of those cases, in all of those cases, death penalty was given, which means it was proved that it was rare of the rarest case, and that is the reason why death penalty was given. Now, if suppose I am the individual, the prosecuting lawyer, and I have proved that this individual, these individuals were involved in it, they were guilty of this crime. I have given enough evidences. So once the crime is established that yes, this individual has these individuals have actually performed that crime. Now once the guilty verdict is done that yes, they are guilty, now the next thing is what will be the punishment? What will be the punishment? Now punishment could be, in this case, either you get rigorous imprisonment for life or you get death penalty. Now, what will I do? Because the case is very similar to the Nirbhaya case, as a lawyer, as the prosecuting lawyer, I will read the case and I will try and find similarities in the judgment and in the case. I will read that, the whole case, the whole order, I will try and find similarities. If I find the similarities, I will present it in the court. I would say the Supreme Court in this particular case, looking at this, which was the evidence, declared it to be the rare of the rarest case and awarded death penalty. Now what will happen? The judge will look at that evidence. If the judge agrees to what I have to say, it is an evidence that is the rare of the rarest case. I don't have to prove it is the rare of the rarest case. I have to just find similarities with an earlier case. I will refer that case, I will see that similarity, I will present it before the judge. The judge looks at it, the judge says yes, it is the rare of the rarest case, the judge will award death penalty. Are you getting what I am trying to say? There is an evidence. Why? Because the court of record, whatever is going on in the court of record, all of those are a matter of record and they can be presented as evidence. Anything that happens in the Supreme Court will act as evidence in the Supreme Court, will act as the evidence in the High Court, will act as evidence in the lower court as well. If there is one judgment of the High Court, it will be referred to the other judgment in any of the other High Courts or in the lower court, and that will act as an evidence. Clear? This is what is the meaning of the first idea. Understood this? The first. The second, that is whenever a court is declared as a court of record, that very court also has the right to punish an individual in what? In the contempt of court. So if the individual has done something, said something which falls under the definition of what contempt is, in that case the individual will be punished. The court will have the power to punish that individual. Let's try and simplify this. First, try and understand what is contempt and why contempt. First, try and understand this. See, contempt simply means when you are doing something which is contradictory to what the court's direction is. So, court has directed you to do something, you are doing something which is absolute in contradiction to the court's direction. That is what is contempt of court. Why contempt of court is necessary? Why is it important? See, when you have judicial institutions, the judicial institutions need to act in a way so that their authority is respected by everyone. They have, these institutions that are there, suppose what happens tomorrow, if suppose the Supreme Court says something and there is an individual who says, I will not agree to what Supreme Court says. I will not agree to what Supreme Court says. I will not do what the Supreme Court has directed me to do. And the Supreme Court has no instrument so that they can force him to comply with the judgment of the court. What will happen as a result of it? So tomorrow, if there is a judgment against me, I will also say no, I will also not do it. There is a judgment against some other party, they will also say no, I am also not going to do what the Supreme Court has directed me to do. This is undermining the authority of the court. And this will not happen. This is not something that should happen, because if that happens, what is going to be the result of it? The result of it is going to be that now the court loses its dignity, the court loses its authority, and that is not how judiciary can function. So to maintain the dignity of the court, to maintain the authority of the court, to maintain the impartiality of judges that are there, there is a power that has specifically been given to the courts, which is to punish an individual who is in contempt of the court. Clear? Are you getting what I am trying to say? Clear? So what is contempt? Simply the power of the court to punish an individual who is in contempt, so as to ensure maintenance of authority, dignity and impartiality of the judiciary. Because we are talking about contempt of court. Clear? So we are referring to judiciary. But contempt is a power which is not just enjoyed by judiciary. There are other institutions also which enjoys contempt power, like parliament. Parliament also has contempt power. So in that case, we will refer to parliament. Because now we are talking about contempt of court, so it is a power that is being exercised by whom? By the judiciary. Clear? Are you getting what I am trying to say? Now, contempt of court, there is a law which defines what is contempt of court, and it also tells us who would be punished, on what grounds would be qualified as contempt power, and what would be the punishment for it. And that law is Contempt of Court Act of 1971. The Contempt of Court Act of 1971, it explicitly defines who has this power, what is this power, and what will qualify as contempt. What will be the punishment for it. The Contempt of Court Act of 1971 classifies contempt into two. You can write this. It classifies contempt into two categories. It classifies contempt into two categories. First, civil contempt. Civil contempt. Second, criminal contempt. Criminal contempt. What is civil contempt? What is the definition according to this particular law? You can write any act where an individual has failed, any act where an individual has failed to comply with the directions, the orders, or has failed to fulfill an undertaking given by him to the court. Given by him to the court. The punishment for which is the punishment for which is imprisonment up to 3 years, imprisonment up to 3 years, or a fine, or both, or a fine, or both. Criminal contempt. What is criminal contempt? You can write, if an individual attempts to undermine the authority of the court, undermine the authority of the court, undermine the authority of the court, or interferes with due course of justice, due course of justice by scandalizing, or attempting to scandalize the proceedings of the court. The punishment for which is imprisonment up to 3 years, or a fine, or both, Clear? So the law is very clear as to what the contempt, what is exactly contempt. There are two types of contempt. Either it can be civil contempt or it can be criminal contempt. Civil contempt is where you have failed to comply with the directions that the court has given, or for that matter you have failed to comply with the undertaking that you have given to the court. If that is the case, you will, it may so happen that you will be punished for contempt of court. Or what is criminal contempt? A criminal contempt is where an individual has interfered with or undermined the authority of the court by doing what? Interfering with due course of justice. How? By trying to scandalize whatever is going on in the court. That will qualify as criminal contempt. Now, I'll give you an example of how this functions and how this basically has worked. There was a case that came up in front of the Supreme Court around 2.5 years ago. The case was where Prashant Bhushan, who is a lawyer in the Supreme Court, a very renowned one, he was also associated with the Aam Aadmi Party. He had made a specific comment on one of the Twitter posts of the former Chief Justice of India, where what he was inferring from that very post was that the Chief Justice of India had in his Twitter posted a particular photograph where he was posing with a vehicle, a bike, which was a Harley Davidson bike, which had a cost, it was somewhere around 50 lakhs was the cost of it. Now that particular photograph was taken by an individual who was in front of the Press Club of India or something like that, where he was also there, and he had just posed with the bike. So when he posted that photograph in Twitter, so Prashant Bhushan had commented on the Twitter, that very photograph, that it was a bike which was gifted to him by one of the MLAs or MPs of the BJP, and this led to a lot of debate whether that it was like a bribe and so on and so on. Now, because of this and because of what followed later on, because of the comments that he came up with later on, there was a contempt proceeding taken up against him in the Supreme Court. In the Supreme Court. Now, if you read the definition of what criminal contempt is, the criminal contempt says it is an attempt to lower the authority of the court by trying to scandalize and interfering with the due course of justice. This definition is exactly what he had done. This is what he was trying to do. He was trying to scandalize and lower the authority of the court. He was found guilty of criminal contempt. He was found guilty of criminal contempt. And he should have been punished, but because of because of the lobbying that that is there in India, and because of the fact that there is a specific group of people who have a specific ideology and a specific agenda, they started criticizing the Supreme Court, and not on a judgment which seemed to be out of place. It was the exact definition of what criminal contempt stands for. But that led to finally the Supreme Court also did not do anything and fined him only 1 rupee. He was fined 1 rupee. He was left. And this was not the first time. Prashant Bhushan was not tried for contempt for the very first time. It was his 3rd or 4th case wherein he was being tried for contempt. This is what criminal contempt is. But anyways, if we talk about criminal contempt, now what we understand is that even contempt of court. So I cannot say anything which I want, like what he was doing, because he was not happy with whatever was going on in the Supreme Court. You cannot start saying anything. Even if it qualifies as freedom of speech and expression, there can be a reasonable restriction imposed on it, which is contempt of court. Similarly, defamation, I will be talking about defamation also in details, but for now, defamation is to be understood in this manner. As I said, see, we have the freedom of speech and expression, but it does not mean that in exercise of my freedom of speech and expression, I start defaming someone else. I cannot do that. I cannot do that. Every individual has the right to life. The Supreme Court says this right to life is a right to a dignified life. And an individual's dignity, a very important component of an individual's dignity is his stature, his personality. You cannot start defaming an individual on the basis of this. So even defamation can be considered as a reasonable restriction on freedom of speech and expression. And similarly, when we talk about incitement of an offense, I cannot start saying that no, you should go and kill that individual. And I cannot claim that as being, I'm inciting an offense. So I know you, if you look at certain examples of it, do you know what is hate speeches? Do you know what are hate speeches? What are hate speeches? They are nothing but incitement of an offense. Section 153A of the IPC deals with hate speeches, wherein you are specifically targeting a particular religion. You are trying to incite an offense, and hate speech cannot be claimed as your freedom of speech and expression. Clear? So these are some reasonable restrictions that can be imposed. One of the reasonable restrictions is sedition. Let's talk about the sedition idea. Very important for multiple reasons. UPSC has previously asked sedition as well, but this time again it has been in use for the reason that Supreme Court has so the Supreme Court of India, which previously had upheld the constitutional validity of the sedition law, is in the process of re-looking at the law. They have not yet referred it to the constitutional bench, but they have specifically said that they are in the process of re-looking at the law. So in that case, if the Supreme Court sees that no, it may not necessarily be in accordance to what the Constitution wants, it may so happen that the constitutional bench of the Supreme Court declares it to be unconstitutional. But that is right now going on, and because of it, it has been in news. Now, when we talk about the sedition law, let's talk about, first of all, let's understand what exactly does this provision, it says. No, only then we can go forward with our discussion as to whether it qualifies as a violation of freedom of speech or expression or not. First thing, when was it introduced? Section 124A of the IPC, it was introduced in the IPC in 1870. It was introduced in the IPC in 1870. What does this mean? It being introduced in 1870, it simply means that it is a pre-constitutional law. It is a pre-constitutional law, a law which was enacted by the British to curb the freedom of speech and expression, or for that matter any kind of political criticism of the British government. Clear? So the objective of the sedition law during the British period was very clear. What they wanted to do was, they wanted to explicitly use this particular law and prohibit any form of even legitimate criticism of the British government. Clear? And during the pre-independence period, our freedom fighters like Bal Gangadhar Tilak, Mahatma Gandhi, and others have been prosecuted under this particular law. They have been prosecuted under this particular law. Bal Gangadhar Tilak, he was one of the very first individuals to be prosecuted under, one of the first renowned individuals to be prosecuted under the sedition law. Now, what exactly is the definition of sedition? Let's see that to understand what is the problem with that definition. What does it say? Whoever by words either spoken, written, or by signs or by visible representation or otherwise brings or attempts to bring hatred or contempt against the government established by law. Against the government established by law. Against the government established by law. This is a very important term. Against the government established by law. Now see, what does it say? It says, any individual who has either spoken something or has written something or has come up with a sign or has come up with other forms of visible representation, or for that matter has done anything which would qualify as bringing hatred or contempt against the government established by law. Against the government established by law. Now, what exactly does this very idea mean? When we say government established by law, what does this idea mean and what is the meaning of it? Try and understand this. When we say hatred or contempt against the government established by law, which means if we try and infer what exactly is meant by this, we would infer literally that if the government, if anyone criticizes any policy of the government or any act of the government, don't you think it will fall under this definition? Because if suppose I am talking about a policy of the government which is subject to, I am criticizing it, and I am giving the details of that policy to you. That see, if this happens, this is going to be the result of it. This is the right that you are going to be denied, or this is something which will lead to you paying a higher price for something which you are currently not doing. I am trying to do what? I am criticizing the policy of the government. I am trying to bring contempt against the government established by law. I would like that you also and others like you who agree to that criticism will do what? Now you will not, no, now you will not agree to the government. You might vote against the government, or you might take certain steps against what? No, against the policy of the government. What are you trying to do? You are trying to, no, or what I am trying to do is I am trying to bring contempt against the government. The problem is, it does not say contempt against the state. It does not say state. It does not say India as a nation. It says government established by law, which means any government and any policies that the government has come up with, if you are criticizing it, it falls under the definition of contempt, and therefore it will fall under the definition of sedition. See, there is a further elaboration of it. What does it say? Whoever by above means excites or attempts to excite dissatisfaction towards the government established by law. That is what I am trying to do now. I am criticizing a policy of the government. What am I trying to do? I am trying to excite dissatisfaction towards the government. They have done what? They have committed sedition. They have committed sedition. Clear? Are you getting this? Dekho, what is the most important problem with this definition? The most important problem with this definition is that it literally means you cannot say anything against the government. If you say anything against the government, it would qualify as sedition. It would qualify as sedition. If you say anything against the government, it would qualify as sedition. And if that happens, what is the punishment for it? Imprisonment for life. Imprisonment for life. Clear? Have you understood this? See, this raises a very important question. The question is, first, isn't this what freedom of speech and expression gives us? Freedom of speech and expression says that you have the right to protest, you have the right to express yourself, and in that manner you have the right to even criticize the government. So if that is the case, the sedition law is contrary to our fundamental right, freedom of speech and expression, and hence should have been declared unconstitutional. Because literally speaking, that is what the definition here is. You cannot say anything against the government. It does what? It encroaches upon the liberty of freedom of speech and expression. Because here the term that is used is always government established by law. It does not say the state, it does not say the nation, it says government established by law. And when we use the term government established by law, whom are we referring to? We are referring to the Council of Ministers, the Prime Minister, that is the government established by law, or at the state level, the Chief Minister and the Council of Ministers. We are referring to them. So if we do anything which leads to dissatisfaction against the Chief Minister and the Council of Ministers, or the Prime Minister and the Council of Ministers, that would mean we have committed an act of sedition, literally speaking. So why has this law not been declared unconstitutional? Why is it that this law has not been declared unconstitutional? The reason is very simple. Coming to 1962. So what happens in 1962? See this. There is a case which comes in front of the Supreme Court. The case is called as Kedarnath versus the state of Bihar case. Kedarnath versus the state of Bihar case. So who was Kedarnath? Kedarnath basically was an individual who was associated with a political party which was against the Congress party, So he was like a political competitor. So in one of his rallies, political rallies that he was addressing, he started abusing the Congress party, and he started saying that there are people in the crowd who belong to an institution. Then there was an institution that was in existence called as the CID. Now it is not there in most of the states, have done away with this institution. Then it used to be there. So he referred to that institution and called them as dogs of the Congress party. In his political rally, he started saying this. As soon as his speech was over, he was arrested and there was a sedition charge that was slapped against him. A sedition charge was slapped against him. When it was appealed in the Supreme Court, Kedarnath appealed against the constitutional validity of the Supreme Court, of the case itself, of the sedition law itself. But the Supreme Court said no. Constitutional validity of the Supreme Court upheld the constitutional validity of the sedition law. The Supreme Court upheld the constitutional validity of the sedition law, saying that no, it is constitutionally valid. The law is constitutionally valid. And what was the reason that the Supreme Court gave? The Supreme Court says laws such as the sedition law, you can write this, laws such as the sedition law, acts as a balance between individual rights versus public order. So the Supreme Court says that sedition laws are the manner in which these laws actually function. These laws are certain laws which does what? It creates a check on what? It creates a check on individual rights. So there are individual rights and then there is public order. And there needs to be a balance between the two that is to be achieved. And laws such as the sedition law do what? It ensures the existence of that balance. It ensures the existence of that very balance. So the Supreme Court upheld the constitutional validity of the sedition law in the Kedarnath versus the state of Bihar case, and the Supreme Court also did what? The Supreme Court made a remark. Remark was that laws such as the sedition law acts as a balance between individual rights and public order. But the Supreme Court also very much modified the manner in which and the condition in which the sedition law was to be applicable. And what did the Supreme Court say? See, sedition will only be applied when incitement to violence or intention or tendency to create public disorder or cause disturbance in public peace. That means, if this is not what the individual is doing, it will not qualify as sedition. So what is sedition? Sedition is only when an individual has spoken something which has led to incitement to violence, or he has an intention or a tendency to create public disorder or cause disturbance of public peace, or do what? Cause disturbance of public peace. Only when this happens, then in that case the individual is to be charged and prosecuted under sedition law, not otherwise. Not otherwise. Which means through or under the Kedarnath judgment, the Supreme Court fundamentally altered what? The meaning of sedition. The meaning of sedition. Clear? Understood this? Next, see. The next case. Indra Das versus the state of Assam and Arup Bhuiya versus the state of Assam. In this case, what happened? The Supreme Court says only speech that amounts to incitement to eminent lawless action can be criminalized under sedition. Only speech that amounts to incitement of eminent lawless action can be criminalized. So, if I am speaking something which is not inciting eminent violence, eminent lawless action, that means eminent violence. If it is not inciting any eminent lawless action, it will not qualify as sedition. It will not qualify as sedition. It will not qualify as sedition. Even if I have said something against the government, to an extent, even if I have said something against the country, India, but I am not inciting violence, I am not inciting eminent lawless action, my actions, my speech will not qualify as sedition. Next, Menka Gandhi case, very important. Details of this case I will be discussing under Article 21. But in the Menka Gandhi case, the Supreme Court said what? The Supreme Court said that criticizing the government policies, see this, criticizing and drawing general opinion against the government policies and government decisions within a reasonable limit does not incite people to rebel and is inconsistent with freedom of speech. Just write this, Menka Gandhi case, the Supreme Court stated, what did the Supreme Court state? Criticizing and drawing general opinion against the government policies, general opinion against the government policies and decisions with a reasonable limit, does not incite people to rebel and therefore is consistent with freedom of speech. Freedom of speech. Clear? So, if you can see the last point that has been written is the judgment saved the citizens from unquestionable actions of the executive, which means if you are doing something which is questioning the executive policies or decisions of the executive, you cannot in any way be prosecuted for that. Simply criticizing or questioning it, you cannot be done. That cannot be done. Clear? Next, the Balwant Singh versus the state of Punjab case. This is one of the most important cases. Balwant Singh versus the state of Punjab case. In this case, see what the Supreme Court says. The Supreme Court overturned the conviction of sedition under section 124A of the IPC that Balwant Singh was convicted for. What did the Supreme Court say? The Supreme Court says that when an individual raises slogans such as things like Khalistan Jindabad or something like that, even this will not qualify as sedition. Even such slogans do not qualify as sedition. Why? The Supreme Court says yes, this does undermine the sovereignty of the government. It does undermine the sovereignty of the government, but it does not incite eminent violence. It does not incite imminent violence. In the Balwant Singh versus the state of Punjab case, the Supreme Court came up with a decision which says that even if such is questioning, even such statements like, when you raise such slogans, even if it is questioning the legitimacy, the sovereignty of the government, you are questioning the sovereignty of the government, but you are not inciting imminent violence. And because you are not inciting imminent violence, there can be no sedition charges that can be taken up. So, if you look at the Supreme Court has to say what exactly, according to the Supreme Court, over these 4 or 5 cases that we have discussed, what exactly does sedition mean? According to the Supreme Court, sedition is when an individual is inciting imminent violence with an objective of overthrowing the state. What is the Supreme Court saying? What is sedition? An act which is inciting imminent violence with an objective of overthrowing the state. Only that action will qualify as sedition. Only that action will qualify as sedition. Clear? If you have not written this, you can write this. Supreme Court says what? Any act which incites imminent violence with an objective of overthrowing the state, with an objective of overthrowing the state. Clear? This is what sedition is. And because of the change, though it has not, the language remains the same, the interpretation has been changed by the Supreme Court, and that is the reason why even today sedition law is constitutionally valid and we are still continuing with the law. Clear? Is this clear, everyone? See, there is no doubt that there has been a misuse of sedition law. There have been cases, like there was a case in 2010, a case which we refer to as, there was a cartoonist there, Asim Trivedi. What happened was that he had depicted a cartoon, he had made a cartoon wherein the Indian Parliament was portrayed as, it was portrayed not in the right light. What happened? He was jailed. There was a sedition charge that was registered against him and remained in jail for 2 years, when the Supreme Court actually acquitted him and said, though this is not sedition. Because the Supreme Court's definition is very clear. What is the Supreme Court's definition? Any act which incites imminent violence with an objective of overthrowing the state. And nowhere Asim Trivedi had done that. There was a case which was registered against one of the actresses. She was from the southern part of India and she had visited Pakistan, came back to India, and when she was asked a question on the airport, what do you think about the people of Pakistan? She simply made a statement wherein she said that people of Pakistan are not demons, and there was a sedition charge case that was registered against her. So these cases that are there, it shows that there are some instances where the law has been misused. But the Supreme Court is very clear on this very idea. The Supreme Court says misuse of law is not a reason for considering the law to be unconstitutional. Misuse of law cannot be the reason. Yes, there is a misuse of sedition law, no denying the fact. but misuse of law cannot be the ground of declaring it to be unconstitutional. That cannot be the ground, because there is misuse of almost every law. If you start considering that misuse of a law, the law to be the valid ground, most of the laws will be declared unconstitutional because the executive has a tendency of misusing it, over exceeding its jurisdiction, and that is the reason why we have the judiciary. But misuse of the law cannot be the ground for declaring a law to be unconstitutional. And the Supreme Court has this view on the sedition law. But yes, now the Supreme Court is again going through this very law, and it may so happen that if it is referred to the constitutional bench, the constitutional bench may declare it to be unconstitutional. It may so happen. And it may so happen that you will see a new sedition law. It's not that sedition law will not be there. There may be an amendment to the sedition law where the language is changed. That is very much possible. That should happen, because we should have a law against sedition. But if we change the language, what will be the result of it? At least there would be no misuse of the law. So there is no denying the fact that what we need to do is we need to amend the sedition law. Clear? So this is all about sedition. This is where I am going to stop for today also. The next class I have to take up a discussion on, first I will be discussing the defamation, section 399 and section 400, section 499 and 500, I will be discussing that, and then we will move on to the next discussion of article 19. So it will take, next class, article 19 and article 20, this is what we will be able to complete. Clear? That's it. Thank you everyone.